Thank you, Mr. President. Your Excellencies, I'm pleased to introduce the report of the High Commissioner on the database of business enterprises involved in certain activities in the Israeli settlements under this Council's Agenda Item 2. This report is the first since the Council's Resolution 53/25 last year, which provided the basis for continuing resources for this mandate. As with many mandates of the Council over the last 2 years, funded as they are under the regular budget of the United Nations, recruitment of staff and therefore the implementation of activities has been delayed and slowed by the liquidity crisis facing the Secretariat and the subsequent restrictions placed upon the office. Further to Resolutions 53/25, the report describes OHCHR's call for input made in May of this year for submissions by states, civil society organizations, and other stakeholders in order to comprehensively update the database first published in 2021, in which 112 business entities were listed and updated on a limited exceptional basis by the High Commissioner in 2023. The 733 submissions received in response to that call for submissions included allegations of the involvement of 596 business enterprises in listed activities. On the basis of preliminary review of these allegations received, which is continuing, 88% came from civil society organizations and individuals, 10% came from states, the remaining 2% came from other stakeholders. As regards the sectors of the business enterprises concerned in the allegations, initial review indicates that 45% concern construction or manufacturing, 14% are in the finance sector, 6% concern agriculture, food or beverage, 4% technology, 4% energy and natural resources, 3% security, and another 11% other business sectors. 13% still need to be classified. In terms of next steps, the report states that OHCHR will pursue the review of the current database and the submissions received and the release of results of its assessment progressively. The Office plans to develop a system by which the addition and the removal of business enterprises will be periodically released through a dedicated web page. Until the next update is made public, the most recent public update of the database continues to be that provided by the Office in our 2023 report. From the normative perspective, the guiding principles on business and human rights remain the key framework for assessing the potential involvement of business enterprises in the activities falling within the scope of this mandate. As described in the report, efforts have been made to strengthen the technical, business and human rights foundations on which this work is conducted, taking into account developments more generally in the understanding and implementation of the guiding principles approach. As a result, going forward, the Office intends a greater reliance on the involvement framework of the guiding principles on business and human rights. These principles acknowledge that the corporate responsibility to respect human rights requires that business enterprises avoid causing or contributing to adverse human rights impacts through their own activities and address such impacts when they occur, but also that they seek to prevent or mitigate such impacts that are directly linked to their operations, their products or services by their business relationships, even if they have not contributed directly to those impacts. This typology used in the guiding principles of causation, contribution, and direct linkage, also referred to as the involvement framework, helps refine the understanding of the ways in which a business enterprise may become involved in adverse human rights impact within the overall meaning of the guiding principles and the actions it is expected to take in response. As part of its work to update the database, the Office is working to apply these important distinctions among different forms of investment. In its landmark advisory opinion of 19 July 2024, on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The International Court of Justice reaffirmed that the Israeli settlements in the West Bank and East Jerusalem and the regime associated with them have been established and are being maintained in violation of international law. Further, the court held that the continued presence of Israel in the occupied Palestinian territory is unlawful. In the court's view, member states are under obligations, among others, to abstain from entering into economic or trade dealings with Israel concerning the occupied Palestinian territory or parts thereof, which may serve to entrench its unlawful presence in the territory, and to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation created by Israel in the occupied Palestinian territory. The present mandate and OHCHR's work in respect of it should be understood in light of this clear expression of international law set out by the court. Through its continuing work under Resolution 31/36, read in conjunction with 53/25, the Office aims to promote transparency and to assist both member states and business enterprises in complying with respective obligations and responsibilities under international law. As has previously been the case, any business entity showing that it has ceased involvement in the activities in question will be removed by the Office from the database. The Office looks forward to continued robust engagement with business enterprises, states, civil society, and other stakeholders in discharge of this important mandate. Thank you.